If you are a green card holder living in the United States right now, the next 60 seconds of this video could be the most important 60 seconds you watch all year. Because starting March 2026, the United States government has officially rolled out a series of sweeping new restrictions that directly target green card holders, and every single one of them is already in effect or about to hit. We are talking about bans on business loans, new interrogation procedures at airports, expanded background checks on green card applications filed years ago, and a fundamental shift in how the United States government now views lawful permanent residents. If you hold a green card, if you are married to someone who holds a green card, or if you are currently in the process of applying for one, this video is not optional viewing. This is urgent. Stay with me until the very end, because every single update in this video could determine your future in this country. Welcome back to the Immigration channel. Every single week I sit across from green card holders, in consultations, in live calls, in text messages at 2 in the morning, and I hear the same fear over and over again. People are scared. Not because they did something wrong, not because they have a criminal record, not because they broke any law. They are scared because they are living their perfectly normal lives and the rules keep changing around them without warning. The very foundation they built their American dream on is being shifted, quietly, quickly, and with very little mainstream media coverage. That ends today. I am going to break down every major confirmed change put into effect between late February and April of 2026. Changes that every single green card holder in America needs to understand right now. Let us start with the change that hit hardest and hit fastest. On March 1st, 2026, the Small Business Administration, the federal agency known as the SBA, officially changed its loan eligibility rules in a way that blindsided hundreds of thousands of immigrant business owners across the country. And if you are a green card holder who owns a business or holds any ownership stake in a business, this change is a direct financial blow to your future. As of March 1st, 2026, 100% of business ownership must be held by United States citizens in order to qualify for an SBA loan. That means if you are a green card holder and you own even a small percentage of a business, even a minority stake, your entire business is now disqualified from receiving SBA financing. Gone. Effective immediately. Now here is why that matters so deeply to so many people. SBA loans are not ordinary commercial bank loans. They carry significantly lower interest rates. They come with better repayment terms and longer payback windows. They are specifically designed to help small and mid-sized businesses grow, expand, hire employees, and compete in the open market. For decades, literally decades, green card holders have legally and successfully used these loans to build everything from corner restaurants to multi-million-dollar enterprises. The SBA has always been one of the most powerful financial tools available to hard-working immigrant entrepreneurs who were doing absolutely everything right, following every rule, paying every tax, creating American jobs, and contributing to this economy every single day. And now, with one policy change effective March 1st, 2026, the federal government has shut that door completely. This is not a rumor. This is not political speculation. This is confirmed federal policy. If you are a green card holder and you were planning to apply for an SBA loan, the deadline to act was March 1st, 2026. If you have not already acted, speak with an immigration attorney and a business financial advisor today, not next week, today. Do not assume this policy will reverse itself quickly. You need to plan your business financing around the reality sitting in front of you right now. The second major development is what is happening to green card holders at airports, and this is something thousands of people are experiencing right now across the country. Over the past 3 to 4 weeks, a rapidly growing number of green card holders who traveled to certain countries and returned to the United States have been pulled aside for what is officially known as secondary inspection upon re-entry. These are countries falling within the current travel ban framework, approximately 39 nations under a full travel ban, and an additional 36 nations under a partial travel pause, bringing the total number of high-risk countries to 75. If you travel to any of these countries and you are returning to the United States as a green card holder, you are now at an elevated risk of being stopped, questioned, and delayed at the port of entry. Here is what is critically important to understand. As of the recording of this video, no confirmed cases have emerged where a green card holder was permanently detained or formally deported solely because they traveled to one of these 75 countries. But that is not the complete picture. What our clients and viewers are reporting in significant numbers is that these secondary inspections are lasting hours. People are missing connecting flights. People are suffering real financial losses because they had to rebook travel last minute, and no government official offered any compensation or explanation. The inspections are resulting in release, meaning people are eventually allowed to enter the country, but the process itself is being used as a mechanism of harassment and disruption for lawful permanent residents who did absolutely nothing illegal. If you are a green card holder and you are planning to travel internationally, here is what you need to do right now. First, research whether your destination country appears on the list of 39 fully banned or 36 paused nations. Second, if you are traveling through connecting airports, build in significant extra time between flights. Do not book a tight connection assuming you will breeze through. Third, prepare a simple one-page document that clearly states when you received your green card, the purpose of your travel, who you visited, and the evidence that the center of your life is firmly rooted in the United States. The more documentation you carry showing your ties to this country, your job, your home, your family, your taxes, the smoother your re-entry process will be. The goal is to make it absolutely clear to any immigration officer that you are a lawful permanent resident returning home, not someone exploiting travel to compromise your status. There is a second element to this travel issue that is equally alarming. Social media vetting at the border has escalated dramatically. Green card holders are now being asked to unlock their phones and show their social media profiles upon entry into the United States. This is something that was previously associated with visa applicants and foreign nationals, not lawful permanent residents. But the boundary is being pushed. As a green card holder, you have significantly more legal rights than someone entering on a temporary visa. You are not legally required to hand over your phone or unlock it for inspection. However, and this is critical, refusing to comply can trigger additional delays, extended questioning, and a far more complicated re-entry process. Know your rights, but also know your reality. Be mentally prepared for this before you get off that plane. The third major development involves something called expanded public charge enforcement. And while this one primarily impacts people who are still in the process of applying for their green cards, rather than those who already hold one, it is absolutely essential that every green card holder understands what is coming, because it affects the people around you, and it could affect your own path to citizenship down the road. Expected to roll out at the end of February or in early March 2026, the expanded public charge rule will introduce a more aggressive evaluation system for green card applicants who have used any form of public benefits. The government is building out a systematic framework, essentially a risk scoring mechanism, to identify applicants who have used public assistance programs and classify them as higher risk for public charge findings, which can be used to deny a green card application entirely. If you are already a green card holder, you are legally entitled to access public benefits. That is your right as a lawful permanent resident. But here is the warning that every immigration attorney is sounding right now. When you eventually apply for United States citizenship, the government has been signaling that it may look back at your conduct during the entire period of your green card status. If there are any inconsistencies, any undisclosed use of benefits during a period when you were still being evaluated, any gaps between what you reported and what the records show, that window of exposure is widening under this administration. Consult an immigration attorney before you file for citizenship. Do not assume the past is buried. Under current policy direction, The past is very much alive. The fourth development is one of the most legally aggressive actions this administration has taken against the existing green card community, and it is already affecting real people right now. In late 2025, United States Citizenship and Immigration Services, uscis, issued policy guidance indicating that the agency reserves the right to go back 4 to 5 years and re-examine previously approved green card cases. And in 2026, that review process is actively underway. We have already seen cases, including clients of this office, who went to their United States citizenship interview only to be questioned about the original green card they received through marriage more than 14 years ago. In one specific case, USCIS identified what they described as discrepancies in the original marriage-based green card application and issued a formal notice of intent to rescind, meaning they are attempting to take back a green card that was lawfully granted over a decade ago. Let me be absolutely clear about something. These cases are not yet widespread. This is not happening to every green card holder. But the policy authority to do this exists, it has been confirmed, and it is being exercised. If you received your green card through marriage, through an employer, through a family petition, or through any other pathway, and there is anything in that original application that was incomplete, inconsistent, or that has changed significantly since approval, you need to sit down with an immigration attorney and conduct a full case review before you apply for citizenship, or before you do anything that puts your file back in front of a federal officer. This is not fear-mongering. This is the documented reality of what is happening inside the United States immigration system in early 2026. The fifth and final development speaks to a broader philosophical shift in United States immigration policy that every green card holder needs to recognize and adapt to. This administration is systematically prioritizing wealth and economic output over family ties and humanitarian considerations. We see it in the rollout of the so-called Gold Card, a proposal that would allow foreign nationals to effectively purchase lawful permanent residence in the United States for $5 million. A federal lawsuit has already been filed challenging this program, with petitioners arguing that it creates a two-tier immigration system where wealthy foreign nationals can bypass the legal queue that families have waited in for sometimes 10, 15, or 20 years. Meanwhile, employment-based categories like EB-5 investor visas are being fast-tracked, while family-based petition categories, F-2B for unmarried adult children of permanent residents, F-3 for married children of citizens, F-4 for siblings of citizens, are being deprioritized in both processing speed and policy attention. If you are in one of these family-based preference categories, the message from this administration could not be more clear. You are not the priority. That means you must be your own advocate. File every document on time. Follow up aggressively on every notice. Move through the National Visa Center process as quickly as possible so you are positioned for your visa interview the moment a slot opens. And if the government is sitting on your case without movement, if months are turning into years without explanation, you have every legal right to file a mandamus lawsuit in federal court to compel action. These lawsuits work. They have worked consistently. They force the government to act on stalled cases. Do not fold. Do not wait indefinitely. The law gives you tools, and you should use every single one of them. Here is the bottom line for every green card holder watching this video right now. The rules are changing faster than at any other point in recent immigration history. The SBA loan ban effective March 1, 2026, has closed a critical door for immigrant entrepreneurs. The airport secondary inspections targeting green card holders returning from 75 countries are real, and they are disruptive. The expanded public charge enforcement rolling out in early 2026 is tightening the path to lawful permanent residence. The retroactive green card rescission reviews are already affecting people who have held their green cards for over a decade, and the systematic deprioritization of family-based immigration in favor of wealth-based pathways is reshaping who gets to build a future in this country. None of this means your green card is gone. None of this means your American dream is over. But it does mean that the era of holding a green card and simply assuming everything is fine is over. You need to be informed. You need to be prepared. You need documentation ready at every step. And you need qualified legal counsel by your side before you travel, before you apply for citizenship, before you file any new petition, and before you make any major business decision. The green card is still one of the most powerful immigration documents in the world. But right now, in 2026, protecting it requires more attention than ever before. Stay informed, stay prepared, and I will see you in the next video.